All right, why don't we go ahead and get started and take roll, please?
Commissioner Adero.
Here.
Commissioner Kasher.
Here.
Commissioner Wasserman.
Here.
Commissioner Wynn.
Here.
Chair Remke.
Here. Thank you. Good afternoon. Before we get started, I just wanted to take a minute to talk about the election. Obviously, a busy time for everyone here, and I just want to take this opportunity to thank our very hardworking and dedicated staff. Every division within the agency had a real task to take on and worked really hard and did a great job, whether it's advice on the phones, through email, through formal letter, updating our top 10 contributor list on the ballot measure is a far more difficult job than one would think to make sure that we get it right. We're not double counting. So that is a task. And then obviously enforcement, and we'll talk more about what their efforts were this season, but working hard to get the compliance before the election when it matters most. So thanks to the entire staff and for your hard work and dedication to this job. Okay, with that, any public comment for an item that is not on the agenda? Okay, seeing none. The next item is approval of the October 2016 Commission hearing minutes. Any questions or comments from the commissioners? Commissioner Wynn.
Thank you very much. I just have a question about item number 8, and I don't know if we're going to put all the items up.
Are you on the minutes?
Oh, I'm sorry. I was on the consent calendar.
Usually keep me on
I
track.
had no questions on the minutes.
We're in trouble. Okay, any questions on the minutes? Okay, is there a motion?
I move to approve the minutes.
Second.
Commissioner Adero.
Yes.
Commissioner Kasher.
Yes.
Commissioner Wasserman.
Yes.
Commissioner Wynn.
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, then we'll move on to the consent calendar 3 through 36. And as Ms. West takes her seat, I'll just ask if the commissioners have any items that they'd like to pull from the consent calendar as a result of a conflict or a recusal, not obviously as a result of having to ask questions, which we will have that opportunity. So anything that needs to be pulled for a separate vote? Okay, hearing none, we'll go ahead and start with questions. But Ms. West, do you want to start? And you're going to start with, I know that as we were talking about the election, and as the commissioners are now aware, there are, I believe, 15 items on the agenda that related to the November 2016. So that obviously took a lot of fast work, and commend you and your staff again. But you want to tell us a little bit more about your election efforts and what happened?
Sure. I just woke up recently. Galena was enforcement chief. I really want to thank the staff. It's been a whirlwind experience, and it's been terrific. They really pulled together. They were a team. And it was like all of those speeches that you see at the end of those football movies. It really felt like one of those moments. So it was great. I especially wanted to thank a couple of people. Adrienne Korchmaris is our intake manager, and she was the coordinator of the pre-election efforts, where we reached out to all of the county and city clerks that had elections and asked them to turn in anybody that was giving them trouble on filing. So she came up with a system and we did our first listserv emails and tried to coordinate an en masse kind of opportunity this year. So it worked out great. We got 100% compliance from everybody that was referred to us for both pre-elections. So it was,
so how many are we
amazing.
Talking generally? I don't know if you have a final count about how many people were non-compliance.
Well, we contacted all counties in any city that was over 100,000 for the November election, which was different than the primary, where we were able to contact any city that had an election. And of the 54 counties that were contacted and 43 that are cities that responded, they came back with probably, it was about 35 came back with responses on things they needed help with. And so there were less non-filers the second time around. So we had maybe about 40 that we were contacting and hunting down the first time, and then about 20 the second time. So it was significantly reduced the second time around, which I think is because of the first pre-election effort. So pre-election, they're due 40 days out, 12 days out. And so it really made an impact with the clerks getting that support. So when we got you to file your first pre-election, then you actually filed your second pre-election without us having to contact you. So that was pretty amazing. And then we found out some people were actually qualified as 470 filers. As you know, the threshold went up this year. So it's $2,000 of spending and expenditures contributions. So it's a higher threshold. So some people were filing a pre-election that didn't need to, just needed to be a 470. So the staff worked with all of those people to say, hey, listen, this is truly what you are, and got them to do the proper filings. And what's terrific about all of this is that not only did we get this 100% disclosure before the election, but also we actually dealt with all of the people that maybe won't win and won't return any phone calls after the election. And so 2 years from now, you're not seeing them as a default item on the agenda that we've spent 100 hours to get a hold of. So it's such a benefit to do this and to really kill yourself before the election to get everybody up to speed and filing. So it was just a terrific thing. We had one person in Berkeley who was running for city council, Berkeley City Council, that we actually had to go to court and file papers to get him to do his pre-election report. So Assistant Chief Dave Bainbridge went down and filed the papers and had to actually appear and argue. And I don't know how much of an argument it was. The judge seemed pretty upset with him. So
Not Dave.
Not Dave. No, the candidate. And I don't know if it means anything. The candidate did not win the election, as he said to the papers that he didn't intend to file, and then he did after the judge told him to. So that was great. That was a big success of getting 100%. He was our last straggler, so it was good to get us back up to the 100% mark. So I just want to thank everybody. We also did check the committee names, ballot measures, local and state. We checked mailers, and had tons of pictures from signs. One of the great things about the new web complaint form, lots of sign pictures coming in. So we got to check all the ads, the online ads, all the electioneering communications electronically now. So we got to go into that new, well, it's not new, but it's new for this election regulation. And so it was a highly successful pre-election effort, and the staff should be commended.
And that's with a significant increase in the number of complaints pre-election. And I know that your division's goal is to try to resolve as many of those and close as many meritless complaints as possible, again, before the election, so people don't have that hanging out there.
That's true. In my report, you'll see we got hundreds of complaints, and it was about triple what we normally get. And we got 25% of them have already been rejected. They were rejected before the election, and about 35% of them were opened into cases, and 15 you already see on the agenda. So the amount that we got to turn over of the complaints didn't have merit was what our main goal was, to really reject the complaints that could be used in newspaper hit articles or any mail pieces, and to get them rejected as quickly as possible.
All right, Commissioner Wynn?
Thanks so much, Ms. West. That's really an impressive presentation, so thank you and your staff for that. I just have a question about how much time do you have to do things proactively? So, of course, you're responding to these online complaints, which is a great system, but did you have someone just sitting at their computer just going through ads independently, or, and mailers independently, or were you really hoping that the public would trigger a lot of this work?
Actually, everything that's reach out and all of the ad stuff is almost all proactive. And we have to always thank the UC intern program, because we have terrific interns from the University of California program, and they literally do sit at the computer and try to flag. We give them a little training, and then they have to flag the ads, and they use the T10s, and they look up the Secretary of State information to talk about $50,000 donors and what the major donor disclosure should be. So we literally have people doing that nonstop before the election, and it's quite a job, and we always have to make sure we give them lots of sugar.
Okay, well, thank you. Let's
Just very quickly, I just want to commend your department for the work that you did. I'm super impressed that you got 100% compliance. Let's start with that.
We had to hunt him down, but we got him.
But I'm even more impressed by your proactive efforts. I really think that the last thing a candidate wants is a meritless complaint hanging over their head in the middle of an election. And I think that your efforts are very worthwhile and very helpful to the people of the state of California. Thank you.
Okay, so let's go ahead and move to the consent calendar. I'm sure there are some questions, and I know that the first three matters, 3, 4, and 5, were rather big cases, and I know you perhaps want to do a shout out to your staff on that, because I know that was a tremendous amount of work.
I do. I do. Actually, this obviously is a little bit of an older case, but as you can see, some of the cases are a little bit older because they are so involved. There are so many parties and so many witnesses and so many respondents that even this one is broken up into 3. And so I really wanted to tell you and acknowledge that Senior Commission Counsel Angela Brereton and Special Investigator Ann Flaherty, they just worked their fingers to the bone on this case, and under the direction of Sandra Buckner, who is our chief investigator, and she helps to guide these cases. And it was an amazing amount of work, an amazing number of flow charts and meetings to sit through that, trying to figure out all the different parties, and even just the negotiation of all the different parties. I think everyone at the California Political Attorneys Association was represented in this case, but it was a really vast undertaking, and I couldn't be prouder.
Okay, well, I don't have any particular questions about it. I did have my own flow chart though, because it took me that much. But any?
Yeah.
Why don't we just start with questions, if there are any on any cases?
So I have a question on number 8. So, Mr. Detrick, we have seen him here before, and of course, I thought you guys did a great job, staff did a great job writing this up, and of course did mention that we have had a history with him, but he, if I remember correctly, he agreed to a stipulation and did not pay his fine in conjunction with that stipulation in a past case. And I'm just wondering if, how that played into this write-up for this stipulation.
Thanks for asking. In the prior case, there had been a misrepresentation of whether or not he had paid back the money. He did, in fact, pay the fine in the prior case, as he has in this case, and so he didn't pay that, and that was represented as a mitigating factor. But yes, his priors, as anyone with priors, were taken into consideration. This case, in ordinary terms, could have been a streamlined case, yet he has prior enforcement experience with us, and so it didn't qualify for streamline.
So instead of a few $100s, we're looking at a $3,500 fine. And just to clarify, so he paid all the fines to the agency or to the state ultimately. It was a repayment on the prior to his campaign account, which we do not, in that case, had jurisdiction. We could not enforce that against him.
Correct.
Okay.
Thank you for that clarification.
Okay. Any other questions? Do you want to go back, Commissioner Odero, to one of the other numbers?
Yeah, I just, on 3, 4, and 5, the trifecta.
Oh, yeah.
I want to, again, new best friends. I want to applaud you again for your division's work on this. It was super factually intensive, and I too had my flow chart last night as I was trying to follow the bouncing ball. It was factually very intensive, and I thought that you did a really good job writing it up. I am curious only, and by the way, we see eye to eye on the penalties. So I was very pleased when I saw the penalties. I think that they make sense. I think that the facts support that level of penalties. I just wondered, because I would have gone there, and I wasn't sure if you were going to. I was really very excited when I saw the number, because I was wondering if we were going to see eye to eye. What were, in your mind, the facts that took you to such a, you're not going to like the word discount, but such a small discount or negotiation to being so close to the penalty that would have resulted?
I think as I understand it, as opposed to charging more. More.
No, I'm good with what.
Yeah, no. The factors were the entire scheme. This was an entire way to move money, to get it out of certain people's hands and to get it around, to completely control it, and to be able to tell that story and to have a fine that says, okay, this fine is actually more than the amount of money that you moved because you should not benefit from this. And that was kind of the whole basis for us in trying to get the story out and to let everybody know what happened in this case.
So how did you, I don't think I saw it, and if I did, I missed it, and I apologize. But so who's paying what? I don't have a sense, and I apologize. Is it in here? I don't think
It's why it's broken into 3 different cases. And
right, but
so,
even each one has 3 people or 3 entities
Right.
are paying 50. Let's say the first one, 57,000. Who's
Mhm.
paying what?
it's joint and several liability. So as long as the cashier's check comes from them, they work out who's paying what. Generally, they have side agreements as to who's paying which portion, and especially when there's professional treasurers involved, that generally they come up with side agreements, or it's already in their contract if they get fined, who's going to pay the fine. And for inadvertent violations, obviously not intentional. There's probably, if a good lawyer wrote it, there's probably an exception for that. But generally with joint and several liability, they're all equally liable for the full amount of the fine. So they have to work it out.
So it's always, our concern is not as much where the money came from, just that we get the full payment from this group.
Right.
with
Which is why we
acknowledgement.
broke it into 3, because we needed this group to pay this much, this group to pay this much, and this group to pay this much based on what they did and what their behavior was.
So a couple of 2 or 3 meetings ago, there actually was a breakout of, I think, the candidate herself. Everybody was very concerned about, okay, how much did she pay? How much was
Mhm.
of her check? And so why do you make that distinction?
When you have, like, for instance, in the Solario case, when you have someone that has to pay out of personal or non-campaign funds, there has to be a distinction, because that law only came into effect a couple years ago. And it's a difference, and it's a deviation from how the act is and how you generally have to pay fines under the act. So because of that difference, where they specifically said how you pay these fines, we have to see how you paid that fine.
Great. Thank you. Good job. Thank you.
Any other questions on 3, 4, or 5 where we're on them?
I just have a comment before
Okay,
you
Commissioner
ask the public for
Wasserman?
anything. I just wanted to join in about how pleased I am with how the work that was done on this case. I mean, any sort of conspiracy case with this many pieces. I also like the way it was presented to us. I think breaking it out that way made it easier to digest. And although we still ended up doing our own flowcharts, well, those were probably a little easier than having to start from scratch and rebuilding from just a general narrative. And the whole case is kind of a lesson on what you can do and when you go too far, because of whatever you feel is your political end, because the means are important. Thank you very much.
Thank you.
Okay, any other questions on consent items? Commissioner Casher, anything from you?
No, just like to echo the comments. I think you guys have covered it, but well done. Good job on this case. in these
Okay,
three
thank
items.
you.
And before there's a vote, I do have to pull 2 items off of the consent calendar. Items 34 and 36, which is actually, it kind of dovetails into Commissioner Wynn's earlier comments. Both of those respondents had sent us pictures of their PDFs of their checks and signed STIPs, and they did not get here from the mail. So they will be presented to you again in December, assuming the mail does come at some point. But we will pull them until we physically have the check in front of us.
Okay, so that's 34 and 36?
Yes.
Okay.
Okay. If there are no more questions from the commissioners, any public comment on the consent calendar 3 through 35? Please come to the podium.
Okay, I just have to make sure my business doesn't show. Before I get started, I'd like to paraphrase President John F. Kennedy by saying, I do this not because it is easy, but because it is hard. Good afternoon, Chair Remke and Commissioners. My name is Constance Conley, and I address you on consent calendar number 8 regarding Elk Grove City Council member Stephen M. Detrick. In reading over the stipulation and evidence, given the history here of serious past violations of the California Political Reform Act by Mr. Detrick, I believe the proposed fine assessed is too low. A loud and stern message must be sent here by the Commission. In the summary of facts, staff addresses Mr. Detrick's past violations, which opens the door for further comment by stating, in aggravation, Detrick has a history of violating the act, having twice paid the Commission fines for personal use of campaign funds within the last 3 years. When I read FPPC complaint 14130 regarding Mr. Detrick, it states the respondent reimbursed his committee account for all payments to Bhutan Jones. I immediately thought, I hope the FPPC verifies that he did. Knowing Mr. Detrick and his trouble with the truth, I fault myself for not coming before this commission to request, before approving a reduced fine for personal use of almost $100,000, that you verify that the monies were in fact reimbursed before moving forward. As you found out, Mr. Detrick did not reimburse the committee, and Mr. Detrick was not truthful. So I ask you, when it is stated in the current summary facts that the respondent contends the reporting errors were unintentional, why are you now taking Mr. Detrick at his word? I offer up that in many instances, as required by law, the employer and occupation of contributors are listed on his 460s. Why some but not others? In fact, one contributor listed on the table was cited for missing information. However, that same information on the same contributor was not missing on a previous report. Therefore, the information was known but was omitted. I believe it was intentional. Since Mr. Detrick's past actions were mentioned in the current complaint, I will address what I believe is the most egregious contention levied by Mr. Detrick on the FPPC itself. Mr. Detrick has made it known, even sending it to the press, that there was a substitute final agreement complaint on 14130 that this commission did not see, and that he did not have to repay the $95,000. In fact, when corresponding with him regarding the lack of repayment, Mr. Detrick wrote, and this is a quote, and I can produce these emails, "You do not know all the details that were discussed for the final settlement with the Enforcement Division." I'm sorry, I'm nervous. When I responded that I met with Galena West, and she assured me there was no other stipulation or settlement agreement other than the one that went before this commission, Mr. Detrick responded, and I quote, "Galena was not in the enforcement office when my agreement was made." So who was in the office when this so-called final agreement was made? Dave Bainbridge? Gary Winnick? When I pressed Mr. Detrick on the issue, he wrote, "There is a disconnect between the FPPC executive team and the FPPC board." To what is Mr. Detrick referring? What disconnect? Was there some special agreement made so Mr. Detrick did not have to repay the $95,000 and still pay a minor fine given the amount of money involved? Was there a cover-up by the FPPC? A conspiracy to defraud both the public and this commission? These are fair questions given Mr. Detrick's bold statements. Or should the question be, was Mr. Detrick being untruthful again, trying to deflect his wrongdoing onto the FPPC staff? Nevertheless, these are serious allegations imposed here by Mr. Detrick, and they must be addressed. I'm sad to say that I believe Mr. Detrick has made a mockery of the entire FPPC, the important work that must be done here, and that the public has a right to demand he be held accountable for his current actions as well as past actions. Moreover, this commission has the lawful and official power to do just that. In closing, I hereby request that this commission fine Mr. Detrick the maximum amount of $10,000 for the current complaint, request a full investigation regarding his claims of another settlement attached to 14130, his allegations regarding FPP staff, and instruct staff to investigate the filing of possible criminal charges against Mr. Detrick under Section 91000 of the California Political Reform Act. Thank you.
Thank you. I'll just point out the distinction before what we're here for today regarding the prior stipulation in the resolution. As you know, that was brought back to the commission with a closed session on possibility, what the situation was and what we could do. And so that matter has been fully resolved. we're far beyond any kind of a statute on revisiting that issue. We are here just on this stipulation now with the facts as we know them. And again, we are ruling on this misconduct based with the facts as we know them. So I just want to make that distinction. Any further comments?
Sure, I do actually.
Okay.
When the Detrick came before us again, and I mean for this particular case, I had to think of myself about how I would treat aggravating factors. And I think the initial thought is, the hammer needs to fall because this is a prior violator. But then we'd have to look at the actual violations before us and find a result that is not merely punitive. Certainly, there's an element of that because we're attempting to dissuade and to send a message. But I probably was pretty vocal about my feelings in the prior cases with this person and how I would feel about when they came back. But at the same time, we have to approach these things with balance and fairness, even if we think, how far is that aggravating factor going to move us down the line? So I had to go and think about that and think as objectively and as impartially as possible, and not be ruled by other concerns about beyond what would be fair to impose in this particular situation, given aggravation. Perhaps would I go higher, but in this case, I'm leaving that with enforcement is fully aware of these circumstances, and this falls within the range of what was acceptable to me to vote on in a consent calendar. So I appreciate that, but I think that's the position, at least for my own analysis of the case before us now.
All right, thank you. Any other questions or comments on item 8? Okay, is there any other public comment regarding the consent calendar? Okay, seeing none, is there a motion?
I move approval of the consent calendar items 3 through
35.
36.
Well, 36.
Minus
34 and 30.
Six,
and
right.
36 has been removed.
Right.
Okay. So items 3 through 35, with the exception of item 34.
Second.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, thank you.
I'm still here.
Yes, you are. Would you like to take the next item?
Certainly. Item 37 is more informational. It is an item regarding disgorgement. As you know, in laundering cases, we ask for any active committees to disgorge any contributions that they had received. If you remember back the AB&I Foundry case, we identified one candidate who still had an active committee, Delcy Brooks, contacted Delcy Brooks, and they have refunded the money so that they've given it to the general fund. We received the check, and we will be depositing it into the general fund to keep it afloat as of today. So, that's just more of an update, and that concludes the AB&A Foundry case.
All right, any questions on that? Okay, thank you. Thank you, Ms. West.
Thank you.
So our next item is 38 regarding the cost of living adjustment regulation. Good afternoon.
There we go. Chair Renke, Commissioners, I'm Karen Harrison, Commission Counsel. The Commission is charged with making a biennial cost of living adjustment to certain statutory limitations under the Act. Staff is here today to propose amendments to regulations to make the cost of living adjustments for the period January 1st, 2017 through December 31st, 2018. Regulation 18545 sets contribution limits, voluntary expenditure ceilings for candidates for elective state office and state office holder contribution limits. And Regulation 18940.2 sets the gift limit amount. This gift limit amount is proposed to be amended to $470, which is a $10 increase from the last biennial period. The gift limit amount is also restated in Regulation 18700 and 18730. That's the Guide to Conflict of Interest Regulations and the provisions for conflict of interest codes, respectively. We additionally propose a clarifying language amendment to Regulation 18544. This sets out the cost of living adjustment formula that is utilized in Regulation 18545. We request that the proposed amendments be adopted as submitted.
Okay, thank you. Any questions from the commissioners on this detailed regulation?
Just one question, and that has to do with the fact that I don't usually deal with consumer price indexes in what I do. So it's an elementary question about tying ourselves to Bureau of Labor Statistics figures versus the Department of Finance consumer price index. Is one no longer useful or not valid, or this is the one we're supposed to use, or what's the change for?
We've always used Department of Finance as our source for getting the CPI, and Department of Finance relies on the Bureau of Labor Statistics. So it's both.
It's okay. So it's really just turning to where we get it from, really, but they get it from somewhere else.
And the amendment doesn't affect that.
And I thought it had specifically called out the Department of Finance instead of the Bureau.
What
But
it does is
either way, I think you
clarify the
clarified it, yeah.
language.
Thank you.
Any other questions from the commissioners? Okay, any public comment on this regulation or regulations? Okay, sure.
So thank you for this presentation. So when you did your interested party meeting on this regulation, is it just very formulaic, or do people have strong feelings about it?
You know, we didn't have
You didn't
we didn't
have
have
to
an
for
interested
this.
persons meeting on this because it's just
There really is
it
no
is a
option.
an
formula.
automatic adjustment.
Thank
And
you very much.
What we do, you know, we prepare nice charts showing the limits, and so those will be done. That summarize it all, that have all the numbers for the contribution limits for people, and those will be online.
Yeah, they're very helpful.
If it's totally non-controversial one, we don't do an IP.
Yeah, that's fair.
Okay, no public comment. Is there a motion?
I move approval of this COLA adjustment.
I'll second that.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Thank you. Thanks, Karen. Okay, next is item 39 regarding Form 700. There you go.
Sorry. Hi, good afternoon. I'm Tara Stock, the manager of the External Affairs and Education Division, and I'm here today to request your approval of the updated Form 700 and the related documents. As noted in my memo, there were no statutory or regulatory changes that affected these materials this year, so it's mostly just changes to the dates and the deadlines, and then a few clarifying changes to information that was already included. And now that the gift limit has just been approved, we will go through and make those changes to reflect the $470 gift limit. And with that, I request your approval of the Form 700, the reference pamphlet, and then the Forms 700U and A. And if you have any questions, I'm happy to answer.
Any questions from the commissioners? It's pretty straight.
Good afternoon. This is Commissioner Kasher here. I just had one question regarding this is related to the cover page of the Form 700.
Okay.
And this is somewhat of a this is not a substantive change, but I think it's something that I want to just make mention of that we might consider doing in a future update. In Section 1, it gives the filer the option of listing more than one position, so they could submit a Form 700 for multiple agencies, for example.
Right.
And so there's the option to do that on the line below, or you could submit an attachment. And then in Section 3, you are to check a box for whether or not it relates to an annual statement, assuming office, or perhaps leaving office. And it was brought to my attention actually by someone else, but it would seem that in Section 3 it might be useful to have somewhere to indicate for which position or which agency the filer is submitting either the annual statement or an assuming office, because it could be the case where there is an individual who is submitting a Form 700 for two separate agencies, one in which they're assuming an office and another in which they are just continuing to file a standard statement for their annual statement. So it's more of just a suggestion. It's certainly not a substantive change, but maybe something we might consider for a future update of the Form 700.
I think the reason that it's set up this way is because generally, if you're doing an expanded statement for more than one position, it's only going to be an annual statement. Because if you're doing like one assuming and one leaving, the periods covered are going to be different. So generally we would require two separate statements in a situation like that. So usually the expanded only applies to the annual statements.
But I think the issue of multiple filers filing multiple filings is an ongoing issue. And definitely with our new e-filing system, it's something we're tackling and addressing to make it easier for everyone to comply and get it straight.
Right.
That fair to say? All right. Any other questions or comments? Any public comment on item 39 regarding Form 700? Okay, seeing none, is there? Oh,
Sorry, I'm so sorry. I should have spoken up a minute ago. So what are we going to do with what Commissioner Casher has just said? Are we going to punt this to next year? Are we going to? To me, it makes sense to make that kind of a change. Is it too late? I don't know what the timing is of this.
Oh yeah, I mean, if at your direction that is what you would like us to do, no, we definitely would have time to do that.
I think we need to look at it though, because I do think it's more complex than I understand. Yeah, I understand, Commissioner Casher. This is Erin. I understand the comment, and it's something that Commissioner Casher sent an email about it a couple of weeks ago. And I do think it's a little more complicated than just adding something onto the form, because if you have, for example, 10 positions you're filing for, even just logistically on the form, trying to figure out how you would indicate which one's an annual and then leaving office. But it's something that so I guess the short answer to your question, Commissioner Dara,
we're punting.
Yes, we're punting. But it's something that I think kind of like Chair Rumpke said, it's an ongoing sort of issue of Form 700s and where they are filed and how many jurisdictions are receiving them. And so it's definitely on our radar to look at all of these issues. And so we can kind of add it to the list of policy decisions that will probably need to be made in the next coming years about Form 700s.
Especially again with the e-filing. And yeah, I jokingly say we're punting it, but I also know that staff is fully aware of these issues and deals with the filer. So no one's getting dinged if they do something wrong or there's a misunderstanding where we work to clarify it. So right now, I would stick with leaving it like this because I think it's too big of a can of worms to try to resolve here. It's kind of like that wordsmithing we sometimes get into. And I do think with timing issues, we do need to approve this form. It does work. It will continue to work. And we'll continue to address multiple filers as we move forward.
That makes sense. Thank you.
If I can just add, and thank you guys for the follow-up. I'm perfectly fine with the form, and I think that and I'm perfectly fine with punting as well. I think that this is something that needs to be taken up and considered. But one other thing I wanted to, just for further consideration, I think for someone who is requesting a copy of the Form 700 and who is trying to themselves make sense of what the filer is indicating, if they are submitting it and it does relate to multiple agencies and they themselves are trying to figure out, what this relates to, you could possibly refer to other information, on other websites and things like that. But for the layperson who's just trying to understand what's being presented here, I think it's most useful for them. But I appreciate that the filer wouldn't be dinged as well. But I'm thinking more for a member of the general public who's trying to make sense of the form. But thank you guys.
Sure. And, right on these forms and obviously on our website provides all the access to call in or email for questions or advice. And I know the staff is more than willing and able and does it daily to respond to those kind of questions. But yes, and again, I hate to use the word punt because I think what we're doing is passing it as it has been and is used and effectively used. And we'll continue to address the issue as a complex issue about people who have multiple jurisdictions and filings.
And if I can just add as to the punting comment, poor choice of words. I move that we retroactively clarify the record to wherever anybody said punting, it gets changed to we are taking it under advisement.
A punt still moves the ball.
Okay. With all of that and there being no public comment, is there a motion?
I move approval of the changes to the Form 700.
I move we punt. I'm kidding. Just so kidding.
Do you second?
I do second that.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Thank you, Tara.
Thank you.
Thank you.
Okay, so the last item is the executive staff reports. Do the commissioners have any questions or comments for staff on these reports? I think we've covered some of that.
Sure, I can't resist making a comment. I mean, I will just say that at the end of getting through this binder every month, I'm always very impressed by the volume of work that gets done month after month after month. So congratulations to staff on that.
Okay, anything else? These will be submitted. Thank you. And with that, I move to adjourn.
And a second?
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Thank you, everyone.
Thank you.
Thank you.